Hello friends, welcome to our class. Today we are going to start Judiciary. Let us see. Judiciary, Supreme Court, High Court. Replaced British Privacy Council in the 1950. Integrated Judiciary. Unlike USA where the federal and the state judiciary. The composition increased from the 31 to 34 in the 2019 originally 8. Appointment by the President, Chief Justice appointment after the consultation with the Supreme Court and High Court judges as seemed necessary. Other judges appointed after consultation with the CGI. The Supreme Court judges and High Court judges collegium system. The consultation with the CGI means the binding the opinion of the Chief Justice of India plus four senior most judges of the Supreme Court Collegium. Third judge's case. High Court. The first time the setup in the 1862 at the Calcutta, Madras and Bombay. The Constitution of the India provides for a High Court for the each state can be the one for the two or more the state 7th Constitutional Amendment Act. At present 25 Supreme Court. The number decided by the President. Appointment by the President. Chief Justice appointment consult the CGI plus Governor. Other judges appointment consult plus the Governor of Chief Justice of High Court. Consultation with the CGI means the binding opinion of the Chief Justice of India plus two senior most judges of the Supreme Court Collegium. Third judge's case. The seniority. The convention appointment has been the violated twice. The 99th Constitutional Amendment Act NJC for the appointment, but the struck down the के Supreme Court. The qualification of the judges. Citizen of India, judges of the High Court 5 years, or the advocate of the High Court for the 10 years, or the distinguished justice in the opinion of the President. No minimum age for the appointment of the Constitutional High Court. The citizen of India, the held that judicial office in the territory of the India for the 10 years, being a advocate of the high for 10 years. No provision of the appointment of a distinguished justice. Oath by the President, by the Governor. Tenure not fixed, holds the office until the attains the age of the 65 years. Question on the age of the determined by the Parliament. Not fixed until the age of the 62 years. Resignation or and removal. The resign to President. Removal on two grounds: the misbehavior and the incapacity not defined in the constitutional. Removal. The resign to the President. Removal on the two grounds on misbehavior and incapacity. The procedure for the removal is the same as the judges of the Supreme Court. The removal process is regulated by the Judges Inquiry Act 1968. The removal motion signed by the 100 member in the Lok Sabha or the 5 member in the Rajya Sabha. The Speaker Chairman may be admit at the motion or refuse the admit it. The Speaker slash Chairman is the constitute a 3-member committee to the investigate the charges. The committee should be consist of A. The Chief Justice or the judges of the Supreme Court, B. A Chief Justice of the High Court, and the C. A distinguished jurist. If the committee find out the judges the guilty of the misbehavior suffering from the incapacity, the House can be taken up the consideration of the motion. After the motion is passed by the each houses of the parliament by the special majority, and the address is presented to the president for the removal of the judges. No judge of the Supreme Court has been the impeached so far. Acting ad hoc and the retired judges. The acting Chief Justice appointed by the President plus Judge of the Supreme Court can also be and the acting CGI when the office of the CGI is the vacant, CGI is the absent, CGI is the unable to perform. Ad hoc judges. In the case of lack of the quorum, that Chief Justice of India can appoint a judge of the High Court as and the ad hoc of the Supreme Court for a temporary period, and with the prior consent of the President and the only after the consulting with the concerned High Court. Retired judges. At any time, the Chief Justice of India can request to the retired judge of the Supreme Court or the retired judge of the High Court act as a judge of the Supreme Court within the prior consent of the President for a temporary period. Acting Chief Justice. The appointed by the President plus Judge of the High Court as and the acting Chief Justice of the High Court when the office is vacant slash Chief Justice is the absent, Chief Justice is unable to perform. Additional judges. The appointed by the President plus delay qualified temporary period not exceeded 2 years. Temporary increase in the businesses areas of the work in the High Court. Acting judges appointed by the President plus a daily qualified temporary period not exceeding 2 years. When a judge of the High Court unable to perform the justice of his the office due to the absence or any other reason appointed to the act temporarily as and Chief Justice of the High Court. Retired judges by the Chief Justice of High Court of a state can request a retired judges of that High Court or any other High Court act as the judges of the High Court that state or the temporary period. The power of the Supreme Court. The originally jurisdiction under the Article 131 in the disputes between the Government of India and a state, between the Government of India and any state or any side once the more other state on the other or between the two or more states. The Supreme Court has the exclusive and the original jurisdiction in the above cases. The original jurisdiction does not extend pre-constitutional treaty, the inter-water dispute, the matter referring the Finance Commission, its jurisdiction, the original jurisdiction in the sense that an aggrieved citizen can be directly go on the Supreme Court plus but not the exclusive. Supreme Court is issue writs and the enforcement of the fundamental rights. Original jurisdiction means the power of a high court to the hear the dispute in the first instance, not by the any approval. The dispute relating to the election of the member of the parliament and state legislature, the member of the admiralty and the contempt of the court, revenue matters, the enforcement of the fundamental rights of the citizen cases, the transferred from the subordinate court and the involving the interpretation of the Constitution. The writs jurisdiction. Article 226 of the Constitution empowered a High Court to issue writs. And the writs jurisdiction of the High Court under the Article 226 is not exclusive but the concurrent with the writs jurisdiction of the Supreme Court and under Article 32. Appellate jurisdiction. Appellate jurisdiction. It enjoys the wide appellate jurisdiction which can be classified under four heads. The appeals in the constitutional matter against the judgment of the High Court if the High Court certified that the case involves in the substantial question of the law that requires the interpretation of the Constitution. Appeals in the civil matter if the High Court is certified first that the case involves in the substantial question of the law and the general importance and second that the questions needs to be decided by the Supreme Court. The appeals of the criminal matter. If the High Court A has the appeal the reserved and the order of the acquittal of the accused person and the sentenced him to the death. Second, has taken before itself any form of any subordinate court of the convention that accused. The appellate jurisdiction in High Court. It has the appellate jurisdiction in the both civil and the criminal matter. The supervisory jurisdiction, the power of the superintendence over the all courts and the tribunals functioning in its the territorial jurisdiction except the military court or the tribunals. The power of the jurisdiction review, the power of the High Court to examine the constitutionality of the legislative, the enactment and the executive order of the both the central and state governments, plus judicial review has the now here been the used in the Constitution. The provisions of the Articles 13 and the 226 the confirm the power of the judicial review on the High Court. As a court, the record of the High Court has the same powers as the Supreme Court. Supreme Court has the power to the review its own the judgment. Second, has taken before the any case from any subordinate court and the convicted by the accused person and the sentence him to death. A third, the certified that the case is the fit one for appeals in the Supreme Court. This jurisdiction was increased by the Parliament in 1970 appeals. The High Court having jurisdiction more than one state. Dadar Nagar Haveli, Daman and Deep, Bombay High Court, Nagar, Andaman and Nicobar Islands, Kolkata High Courts. This jurisdiction was increased by the Parliament in 1970 appeals to the Supreme Court in the High Court. First, has been the appeal reserved an order to the acquittal of and the accused person of the sentence him to the imprisonment for life or on the 10 years. Second, has taken before itself and the case from the subordinate court and the convicted that the accused person and the sentenced him to a imprisonment life or the 10 years. Puducherry, Madras High Court, Lakshadweep, Kerala High Courts, Guwahati High Courts has been the jurisdiction over Assam, Nagaland, Mizoram and the Arunachal Pradesh. Appeals by the special levels Article 116 except by the military court or the court uh, marital discretionary power of the Supreme Court. Advisory jurisdiction. The President to seek to the opinion of the Supreme Court in the two categories of matters. Article 143. On any question of the law or fact the public importance which has been present which is the likely to arise in Supreme Court may be refused. And on any dispute arising out of the any pre-constitution treaty agreement. Power of the judicial review. Power of the court to the examine the constitutionality of the legislative and enactment and the executive order of the both the central and the state government. The court of record. As a court of record, Supreme Court has two power. First, the judgment, proceeding, and act of the High Court are the recorded for the perpetual memory and the testimony, plus the recognized as the legal precedents and the legal references. B. It has power to punish for the contempt of the court either with the simple imprisonment or the fine or then both. The expression contempt of the court has not been defined by the Constitution. However, the expression has been defined by the Contempt of the Court Act of 1971. The other power. The power do not complete justice under the Article 142 used in the Ram Mandir case. The power to review its own judgment. Judicial review originated in USA. Marbury versus Madison 1803 by the Johnson Marshall. The judicial review is the power of the judiciary to examine the constitutionality of the legislative enactments of the executive order of the both central and state governments. The judicial review is the basic feature of the Constitution. Judicial review has now here been used in the Constitution. Some articles explicitly confirm the power of the judicial review on the Supreme Court and High Court. Article 13 decreases that all law that are inconsistent fundamental rights are null and void. Article 32 granting the right to move and Supreme Court for the enforcement of the fundamental rights. Article 226 empower the High Court to issue the direction or the order with the writs for the enforcement and fundamental rights or for any other purposes. Article 372 deals with the constituents in the forces of the pre-constitutions law. Article 131, 132, 134, 136, 143, 227, 245, 246, etc. Judicial review scope in India never the USA not explicitly mentioned even in USA Constitution. Both the American Constitution provides for the due process of the law against that the procedures established by the law of India Constitution also the introduced in Indian Constitution through the Supreme Court interpretation in the Maneka Gandhi case. Judicial activism. The concept of the judicial activism originated in USA. In India, introduced in the 1970s, Justice P. N. Bhagwati, Justice V. R. Krishna Iyer, Justice O. Chipampa Reddy, and the Justice D. A. Desai. The judicial activism refers to the proactive role played in the judicial and protection of the rights of the citizen and the promotion of the justice in the society by the interpreting the roles of the executive and the legislative. The concept of the judicial activism in the closely related to concept of the public interest litigation PLI. The prior justice The V.R. Krishna Iyer is the Justice P.N. Bhagwati, also known as variously as the social action litigation, the social interest litigation SIL, and the class action litigation CAL. The relaxation of the traditional rules of the locus standing. Any public spirited citizen or the social organization can move the court for the enforcement of the rights of the any person or the group. This case falling under the following categories with not be uh, entertained as a PIL. The landlord tenant matters. The services matter for the those pertaining that the person and the granted. The complaints against the central state government department and the local bodies, the addition, the admission to the medical and other educational institution, the petition for the early hearing of the cases pending in the High Court and the subordinate court, the judicial restraint, the emphasize that the judiciary that the judges should be limited here role in the interpreting and applying the law, reforming from the making or the altering law, and which is the responsibility of the legislature. The Tribunal Part 4 14A, added by the 42nd Amendment Act of the 1976, the Article 323, Administrative Tribunal. The Parliament can take out of the adjudication and the services related to dispute from the civil court and the high court and place before the administrative tribunal. The Article 323, Parliament and the state legislature can establish tribunals. The hierarchy can be the made among the establishment tribunal. This tribunal will be deal with the matters such as first taxation, B. Foreign exchange, import and export, C. The industrial labor, D. Land reform, E. Selling urban property, F. The election of to parliament and state legislature, G. Food staffs. The Central Administrative Tribunal CAT. The setup in the 1985, the principal bench on the Delhi additional benches in the different state. The CAT was set up during the Prime Minister of the Rajiv Gandhi. The chairman plus the 65 member present sanctioned the strength. The appointed by the President with the approval of the CGI. The tenure 5 years or the age of 65-year chairman and the 62 from the member. The not body by the Civil Procedure Code. The originally jurisdiction in the relation to the retirement, recruitment and all services matter to public servant covered by it. And its jurisdiction extended to the all Indian services that central civil services, civil post and under the central and the civilian employees of the defined services, state administrative tribunals. The Administrative Tribunal Act of 1985 they empowered the central government to establish the state administrative tribunal sets on the specific request of the concerned state government. The Subordinate Council Article 233 to 237 in Part 6. Below the Supreme Court at the district level there is the district judges called the session judges when the hearing the criminal case. The district judges expresses both judicial administrative power, the supervisory power over the all subordinate court in the district, the appeal to the High Court. Can given death sentence the criminal case and the to be the confirmed by the High Court. the appointment, posting, and the promotion of the district judges by the governor of the state in the consultation with the High Court. The qualification for the district judges is advocate or the rep- repealed for the 7 year not already in the government services and should be the recommended by the High Court for appointment. The appointment of the person other than the district judges are made by the governor after the consulting the State Public Service Commission and the High Court. The National Legal Service Authority. The Article 393 and 39A the provides for the free legal aid and the poor weaker section and the society and ensure the justice for all. The articles 14 and 22A also make the obligatory for the state ensure the quality before law and the equal system which the promotes the justice on the basic equal opportunity to all. In the year 1987, the Legal Services Authorities Act as enacted. The National Legal Service Authority for the policy guidelines and the State Legal Service Authority to implement legal service programs. The District Legal Service Authority, Supreme Court Legal Service Authority, High Court Legal Service Authority, the person eligible for the getting the legal services, women and the children, members of the SC and STs. The industrial workmen, the victims of the mass disaster, violence, flood, drought, and earthquake, industrial disasters. The displaced person, the person in the custody, the person whose annual income does not exceed 1 lakh in the Supreme Court legal services. The committee the limits the 1,25,000 and the victims of the trafficking in human beings is the beggar. Lok Adalat. Lok Adalat. One of the ADR, the Alternative Dispute Resolution System, to reduce the burden on the regular court. The first Lok Adalat came in after the independence was organized in Gujarat in 1982. The provided statutory status by the Legal Services Authorities Act 1987. On the court, the free already paid fee will be refunded if the dispute is settled at the Lok Adalat. The award is the binding on the parties plus status of the decree of the civil court plus non-appealable. The permanent Lok Adalat, statutory by the Legal Service Authorities Act 1987. The chairman is or the district judges or the additional district judges or has led judicial office higher in rank. That of the district judges plus 2 people having the experience in the public services, no jurisdiction on the non-compoundable laws. The pecuniary jurisdiction is up to the 10 lakhs. The award final and the binding on the all parties thereto and shall be the majority of the person. The constituting the permanent Lok Adalat final court. Family court. The statutory by the Family Court Act 1984, the established by the state government, the consulting the High Court, the specialized court, the exclusively family matter, focus on the reconciliations. No right to the represented by the legal participationer. The obligatory to the set up the court in the city with the million population. The not bounded by the rules of the evidence in the Indian Evidence Act 1972. Right to the appeal. Only one. The High Court. The Gram Nyalaya Act 2008. The Gram Nyalaya for providing the access to the justice to doorstep the court to the judicial magistrate of the first class, the presiding officer and Nyadhikari, the appointment by the state government and consulting high court, the mobile court with the power of the criminal and civil court, the focus on the conciliation and the conciliators can be appointed, the not bounded by the rules of the evidence but guided by the principle of the natural justice. The appeal in the criminal cases shall, li- shall lies in the Supreme Court of the session and the civil case with the district judges he heard and the disposed on the within the 6 months. Allow the appeal the begging. The Panchayati Raj institution. The PRIs refers to the system of the rural local self-governance in India. The system of the governance of the rural area through the representatives elected by the people. The term is derived from the Sanskrit word pancha, means five, and the ayat means ayat means assembly. That traditionally signifies the council of the five elders chosen by the community to the settle in the dispute and the oversee the local affair. The fundamental objective of the parliamentary representatives institution, the people's participation in development, the democratic decentralization, the part 9 of the constitution. The The 73rd Constitutional Amendment Act of the 1992 added by the new Part 9 to the Constitution of India entitled the Panchayat. The Part 9 of the Constitution consists of the Article 243 to 243O added a new 11th schedules, the 11th schedule to be the Indian Constitution, which the outlines the power, authority and the responsibility of the panchayat. It contains the list of the 29 functions that have been developed in the panchayat. The Balwant Rai Mehta Committee 1957 the examined the working of the community development program and 1952 the National Extension Services. The the three-tier Panchayati Raj system linked through the direct election. The Panchayati Samit should be the exclu- executive body while the Jila Parishad should be the advisory coordinating the advisory body. The district collector should be the chairman of the Jila Parishad. The Alok Mehta Committee 1977 revived the strengthening of the declining of the Panchayati Raj system. The two-tier system, Jila Parishad at the district level and the below the Mandal Panchayati consisting of the group of the village. The district should be the first point for the decentralization official participation of the political parties. The GVK Rao Committee, the review of the existing the administrative arrangement of the rural development and the poverty alleviation program. The district is the proper unit of the planning and the development and the Jila Parishad and should be become the principal body for the management. At the post of the district development, the commissioner should be the created. The uh, Panchayati Raj institution district and the lower level should be the assigned with the important role in respect to the planning. The LM the Singhvi Committee, the revitalization of the Panchayati Raj institution, constitutionally recognized the judicial tribunals and uh, adjudicate controversies about the election to the Panchayati Raj. The Rajasthan was the first state to establish Panchayati Raj. The scheme was inaugurated by the Prime Minister on October 2, 1959. The Nagaur district followed by the Andhra Pradesh. The salient feature of the act are the Gram Sabha body consisting of the person registered in the electoral rolls of the village within the area of the panchayat at the village level. It is the village assembly consisting of all the registered voters in the area of the panchayat. It may be exercise such powers and perform such functions at the village level as the legislature of the state determines. The structure of the Panchayati Raj institution (PRIs). The three-tier system of the Panchayati Raj in every state consisting of the following: the panchayats at the village level, the panchayat at the intermediate level, and the panchayat at the district level. However, the state having the population exceeding 2 lakhs may not be constituted panchayat at the intermediate level. The election of the chairperson and member of the panchayat. All the members of the panchayat at the village, intermediate, and the district level shall be elected directly by the people. The chairperson of the panchayat at the village level shall be elected in the such manner as determined by the state legislature. The chairperson of the panchayat at the intermediate and the district level shall be elected indirectly by the form of amongst the elected members and thereof. The Article 243F, that the minimum age the contesting panchayat election in the India is the 21st year. Duration of the panchayat. The 5-year term of the office of the panchayat at the very level from the date to the first meeting. However, it can be dissolved before the completion of the term. The fresh election is the constituted panchayat shall be the completed before the expiry of its duration of the 5 years. In case of the dissolution before the expiry of the period of the 6 months before the date of its dissolution. However, the remainders of the period for which the dissolved the panchayat would be have the continued is the less than the 6 months. It shall not be necessary to hold any election for the constituting the new the panchayat for such a period. Moreover, the panchayat constituted upon the dissolution of the panchayat before the expiration of the duration shall be continue only of the remainders of the period for which the dissolved panchayat would have the continued to hold any not necessary dissolve. The preservation, the reservation of a seats scheduled caste and scheduled tribes in the all three tiers in the proportion of their population and the total population in the panchayati areas. And the state legislature shall provide for the reservation of the office of the chairperson in the panchayat at the village or any other of the scheduled caste and the scheduled tribes. The reservation of the seats well as the reservation of the offices of the chairperson in the panchayat for the scheduled caste and the scheduled tribes will be case in the have effect on their the expiration of the period as specified Article 334. The presently the reservation in the total list the 2013. The provision related to the reservation of the seat panchayat, both chairperson and the member for the scheduled caste and not applicable to the state Arunachal Pradesh. This provision was added later by the 83rd Constitutional Amendment Act 2000 of the rationale that the state inhabited fully or indigenous tribal people that they are the scheduled caste. The reservation for the seat for women. The Act provides for the reservation of the seat less than the one third of the total number of the seat for the women, the including number of the seat reserved for women belonging to the scheduled caste and the scheduled tribes. The further not less than the one third of the total number of the office of the chairperson in the panchayat and each level shall be reserved for the women. The reservation of the seat for other backward classes. The Act authorized that the state legislature to make the provision for the reservation of the seat in the any panchayat or offices. Chairperson in the panchayat at any level is a favor in the backward classes. Disqualification of the member of the panchayat. A person shall be the disqualified for being the chosen as or the for being the member of the panchayat if he or she is so disqualified under the any law the time being for force or the any purposes of the election to be legislature for state concerned for the under the any law made by the state legislature. The all question of the disqualification shall be referred to the such authority and the determined by the state legislature. The power and the function of the panchayat. The state legislature may empower the panchayat with the power of the authority or may be necessary to enable them to function and institution self-government. The state provision for the devolution of the power and the responsibilities upon the panchayat at the priorities level any contain the finances of the panchayat. As per the provision regarding the finance of the panchayat or state legislature may authorize the panchayat to levy the collect the appropriate taxes, duties, tolls and fees. The assign the panchayat taxes, duties, tolls, fees and levied and collected by the state government. The provide for the making grants in at the panchayat from the consolidated fund of state. The provide for the constitution of the fund and the crediting the money of the panchayats. The state election commission. The superintendent's direction of the control of the preparation of the electoral rolls and the conduct of the all the election to the panchayat. It consists of the state election commissioner to be the appointed by the governor. He is the condition of the service and the tenures of the office shall also be determined at the governor, and he shall not be removed from the office experts and manner of the grounds of the prescribed for the removal of the judges of the state and high court. Audit of account. The state legislature makes the provision for the maintenance of the uh, accounts by the panchayat and the auditing the such accounts. The application of the union territories. The provision of this part is applicable to the union territories, but the president may direct that they would be applied to union territories subject such as the expansion of the modification of he may the specify the exempted state of an area. The act does not apply to the state Nagaland, Meghalaya, Mizoram, and the certain other areas. These areas include the scheduled area and the tribal areas in the state, the hill area and Manipur, and which the district councils exist. The Darjeeling district, West Bengal. For this, Darjeeling Gorkha Hills Council exists. However, the parliament may extend the provision of the part of the scheduled area and the tribal area. The subject to the such exception and the modification it may as a state finance commission. The governor of the state shall be constitute a state finance commission after the every 5 years to review the financial position of the panchayat. The state legislature may provide for the composition of the state finance commission, the required the qualification of its member and and the manner of their selection. The state finance commission shall make the following recommendation to the governor of the state. The principle that would be govern the distribution between the state and the panchayat of net proceeds of the taxes, duties, tolls, fees levied by the state, the allocation of the shares among the panchayat at all level, the determination of the taxes, duties, tolls, fees, and name is assigned by the panchayat. The grants in aid the panchayat from the consolidated fund of state. The measures needed by improve the financial position of the panchayat. The governor shall be placed of the recommendation of the commission along with the action taken a report before the state legislature. The Central Finance Commission shall also suggest that measures needed to the augmented the consolidated fund of state is supplemented by the resources of the panchayat is the state on the basis of the recommendation made by the State Finance Commission. The same function at the Finance Commission will be performed the urban local bodies, but the interference the court of the electoral matters, the act of the bars interference by the court is the electoral matter is the panchayat. The compulsory provision and the voluntary provision. Compulsory provision, the organization of the Gram Sabha three-tier system, direct election to the all seat of the three-tier, indirect election of the person of the panchayat at the intermediate or district level, 21 years to be the minimum age for the contesting election, the reservation of the seat both member and the chairperson for the SC and ST, the reservation of the one-third seat both the member and the chairperson of the women in the panchayat at all three levels, the fixing tenure of the 5 years and the panchayat and the holding the fresh election within 6 months in the event of the suppression of the panchayat. Voluntary provision, the endowing the Gram Sabha with the power and function, the manner of the election of the chairperson of the village panchayat, representation to the chairperson of the village panchayat in the intermediate and district panchayat, the representation of the MPs, MLAs, and Panchayati Raj institution, reservation of the OBC, the all sum of the function at the 11th schedule, the assigning the Panchayati Raj institution levy tax duties, grants in at the PRI out of the consolidated fund, the compulsory provisions. The establishment of a state finance election commission. Voluntary provision, providing for constitution of the funds and crediting all the money of the panchayat. The PISA Act 1996 provision of the Panchayat extension of the Panchayat Area Act 1996 that extend the provision of the Part 9 of the Constitution relating to the Panchayat to the 5th scheduled area in the silently modified form. The 6th schedule and the fifth schedule area in the India are design, designated region within the 10 state Andhra, Telangana, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha, Rajasthan that have the significant tribal population. As per the 73rd Constitutional Amendment Act 1992, the provision of the Part 9 of the Indian Constitution relating to the Panchayat are not applicable to the 5th schedule area. The feature of the PESA Act 1996. The every Gram Sabha shall approve the plans, program, and the project for the social and the economic development before they are taken up the implementation by the Panchayat at the village level, and the responsible for the identification of the beneficiary under the poverty and the elevation and the other program. The every panchayat at the village level shall be the required to obtain from the Gram Sabha the certification of the utilization of the fund from the above plan, the program and the projects. The reservation of the seat in the scheduled area in every panchayat shall be the proportion to the population of the communities for the whom the reservation is sought to be given under Part 9 of the Constitution. However, the reservation for the scheduled tribes shall not be less than one half of the total number of seats. The further all seat chairperson of the panchayat at all levels shall be the reserved for the scheduled tribes. The state government may nominate such scheduled tribes have been not reservation in the panchayat at the intermediate level of the panchayat at the district level. However, such a nomination shall not exceed one-tenth of the total member of to be elected in that the panchayat. The Gram Sabha or the Panchayat at the appropriate level shall be the consolidated before the making the acquisition of the land. The recommendation of the Gram Sabha or the Panchayat at the appropriate level shall be the mandatory for the grant of the prospecting the licenses the minimizing the less minor minerals in the scheduled area. The prior recommendation of the Gram Sabha or the Panchayat at the appropriate level shall be the mandatory of the grants a concession for the exploitation of the minor minerals by the auction. The state legislature shall ensure that the Panchayat at the appropriate level and be the Gram Sabha or the onward specifically with the power of the enforce the provisions or the regulated the restricted shall be the consumption or any inter intoxicate the powership the minor force areas the power to be the prevent alienation of the land in the scheduled area and the take the appropriate action to the restore the annually full the aligned and the scheduled tribes, the power to the manage the village market, the power to exercise control over the money lending to the scheduled tribes, the power to exercise control over the institution and functionaries in the social sector, the power to control the local plan and the resources of the such plans and the including tribal sub plans. The municipalities. The municipality is also known as the urban local bodies and it refers to the system of the urban local self governance in India system, the governance of the urban areas through the representatives elected by the people system urban local government was constitutionalized through the 74th Constitutional Amendment Act of the 1992 at the central level. The subject to the urban local government deals with the following three ministers: the Minister of the Housing and Urban Affairs, Minister of the Defense, and the case of the constant contaminant boards, and the Ministry of the Home Affairs, and the case of the urban territories. Evolution of the urban bodies. In 1688, the first municipal corporation in India was set up at Madras. 1726, the set up Bombay and Calcutta. Lord Mayor resolution of the 1870 on the financial decentralization. Lord Ripon Lippon Resolution of the 1882 has been held as the Magna Carta of the local self-government. He is called as the father of the local self-government in India. The Royal Commission of the Decentralization of 1907, the chaired by the Hob House. The Government of India Act of the 1990, the local self-government became the transferred subject in the 1924. The Contempts Act of the passed by the Central Legislature. The Government of India Act of the 1935, the local self-government was declared the principal provincial subject. 74th Amendment Act of 1992. The new Part 9A, the UPSC 2014, the Constitution of India. This part is entitled as the Municipalities and the consists of the provision for the Articles 243P to 243 ZG. The added 12th schedule, which is contain the 18 function is the municipalities. It deals with the Article 243W. It Act gave the constitutional status and municipalities. That is the justiciable part of the Constitution. In other words, the state government are under the constitutional obligation to adopt the new system of the municipalities. The salient feature. The three types of the municipalities consider following the three types of the municipalities in every state. The Nagar Panchayat by the whatever named called for the transitional area, the municipal council of the smaller urban area, the municipal corporation for the larger urban area. But there is one exception. If there is an urban area where the municipal services are being provided by an industrial establishment, that the governor may specify that the area to be the industrial township. In such case, the municipalities may be the constituted the composition. All the members of the municipalities shall be elected directly by the people of the municipal area, the state legislature. The provided manner of the election of the chairperson of the absorption of municipalities. A person having the special knowledge to municipality administration without the right to vote. The member of the Lok Sabha and the State Legislative Assembly. The member of the Rajya Sabha and the State Legislative Council registered as the electoral within the municipal area, the chairperson of the committee and the other the ward committee, the consisting of one more wards within the territorial area of the municipalities having the population of the 3 lakh or more. The reservation of the seats, the compulsory provision, the scheduled caste and the scheduled tribes, every municipalities and corporation of their population. The reservation of the less than the one-third of the total number of the seat and the women including the number of the seat reservation may not be belonging to the Supreme Court SC and STs. Voluntary provision. The state legislature may provide for the manner of the reservation of its chairperson in the municipalities for the SC and ST women. The reservation for the OBC. Duration of the municipalities. The Act provides for the 5-year terms of the office of the every municipalities. Further, the fresh election to the constitute a municipality shall be the completed before the expiry of its duration of the 5 year. In the case of the dissolution, before the expiry of the period of 6 months from the date of the dissolution. Uh, but where the remainder of the period of the less than 6 months, there shall not be necessary to hold any election. Municipalities constitute after the And the premature dissolution does not enjoy the full period of the 5 years, but the remains the office only for the remainder but the period of the period. Disqualification. The person shall be the disqualified for being the chosen as a being a member of the municipalities if he is so disqualified under the law of the time being the force the purposes of election to the legislature of the state concerned or the any other law set by legislature bars of the contest election. The minimum age of the contest 21 years. The questions of the disqualification shall be referred to the such authority as the state legislature determines. State Election Commission. The superintendent direction and the controller of the municipalities election. The state legislature may make provision with respect to the all matter related to the election to the municipalities, the power and the function. The state legislature may be in the municipalities with such power and the authority as may be the necessary for enable them. The function is institutional self-government. The function. The state legislature may the authorize the municipalities the levy the collect the appropriate tax duties and fees. The assign the municipalities tax duty toll fee levied and collected by the state government. The provider for the making grant aid and municipality from the consolidated fund of the state and provide for the constitution of the fund and the crediting all monies and the municipalities. The finance commission same function as discussed in Panchayati Raj institution audit of the account. The state legislature may be make provision with respect to the maintenance of the accounts by the municipalities and the auditing the such the accounts. The application of the union territories, the provision of the part of the applicable to the union territories, but the president may direct that they would be applied to union territories subject and such a exception by the modification as may be specified the exempted area. The act does not apply to the scheduled area and tribal area in the state. It shall be not affected the functions and the power of the Darjeeling Gorkha Hills Council West Bengal. The parliament may be extended provision of the part of the scheduled area and the tribal area. The subject such as exception the modification may be specified. The District Planning Committee. The every state shall constitute at the district level and district level planning committee to consolidated and the plan prepared by the panchayat and the municipalities to the district and the prepare the draft development plan for the district as a whole. The remember that the constitution is the salient is the composition election function. It is the setup the legislature decided. It only the serve the fourth fifth of the member of the district planning committee should be the elected and elected member of the district panchayat and municipalities and the district from the amongst them themselves and the representation of the member a committee should be proportion of the ratio between the rural and the urban population of district. Metropolitan Planning Committee. Every metropolitan area shall be the Metropolitan Planning Committee prepared a draft the development plan. The state legislature may make the provision for the composition, election, and representation function act. The act laws down the two-thirds of the member of the Metropolitan Planning Committee should be elected by the elected member of the municipalities and chairperson of the panchayat in the metropolitan area amongst themselves. The representation of these members in the committee should be proportional to the ratio between the population of the municipalities and the panchayat in the metropolitan area. The bar and the interference of the court electoral matters. The act as the bar of the interference by the court in the central matters of the municipalities. Types of the urban governments. The municipal corporation, the administration of the big city, the establishment established in the state by the state legislature and union territories, the parliament of India. The administrative framework, it has a three authority council, the deliberative and the legislative wings and the municipal corporation. The councillors are the directly elected by the people, but few the nominated. Composition reservation governed by the 74th constitutional amendment. The council is headed by the mayor. The mayor he presides over the meeting of the council, governmental head, and he has the 1 year near by them. The standing committee is constituted by the field that takes the decision. They are the fields, languages, and cabinet as municipal commissioners. The implementation of the decision taken by the council and the standing committee. The chief executive authority is appointed by the state. Municipalities, the established for the administration of the towns and smaller cities. They are also known as the various other names like the municipal council, municipal committee, and municipal board and the municipality city municipalities and other. The like the municipal corporation, the municipalities also has the three authority, namely the council, the standing committee, and the chief executive officer. The council is headed by the president and chairman. Unlike the mayor of the municipal corporation, he plays a significant role in the provisional of the municipal administration. Apart from the presiding over the meeting of the council, he enjoys the executive power. Notified area committee. For the fast developing town and the industrialization for the town which does not yet fulfill all the conditions and necessary for the constitution of the municipalities, but they are otherwise considered the important by the state government since it is established by the notification in the government gazette. It is called the uh, notified area committee. It's the power the function meeting um, mentioned in the state notification. But unlike the municipalities, the entirely nominated body, thus is either the elected body nor the statutory body. Town area committee for the administration of the small town. It is the semi-municipal authority and they ensure that the limited number of the civil function like the drainage roads. It is created by the separated act of the state legislature. It may be wholly elected, wholly nominated by the state government, or partially elected and the partially nominated. The cantonment board for the municipal administration for the civilian population in the cantonment area. It is set up under the Cantonment Act of the 2006, the legislation and elected the central government. It works under the administrative control of the defense minister. It is a central government. The the cantonment board and consists of the partially elected and the partially nominated member. The elected member hold the office of term of 5 years, while the nominated member, it ex officio member, the continue as long as they hold the office of the situation of the station. The military of the officer condemning the station is the ex officio president of the board and the presides over the meeting. The vice president of the board is elected by the elected member from the amongst themselves for the term of the 5 year. The function performed by the cantonment board and similar to those the municipalities, the executive Office of the Cantonment Board and appointment by the President of India. Township. This type of the urban government is established by the large public enterprises to provide the civil amendments. It staff workers who lives in the housing colonies built near the plant. Thus, the township for the urban government has been no elected members. At Port Trust, the Port Trust is established in the port area and so that the town purposes. First, the manage the protect and port. B. The provide the civil amendment is the port trust is created by the court act of the parliament that consists of the both elected and nominated member special purpose agencies. These functional local bodies and established as the statutory bodies by the act of the state legislature. They function the autonomous body and the deal with the functions allotted to them independently to the local urban governments. Thus, they are not the subordinate agency of the local municipal bodies. Note: the Central Council of the local government was set up in the 1954. It was constituted under the Article 263 of the Constitution of India by the order of the President of India. The Council is the advisory body. It consists of the Minister of the Urban Development in the Government of India and the Ministers of the Local Self-Government State. The Union Minister acts as the chairman of the Council. Union Territory. The Union Territories are those areas which under the direct control of the administration of the central government. Hence, they are also known as centrally administered territories. Reason for the creation of the Union Territory: the Delhi Chandigarh Administrative Region, the Puducherry, Dadar Nagar Haveli, Daman and Diu cultural distinctiveness, Andaman Nicobar Lakshadweep strategic importance. The Ladakh, large area and sparsely populated and very difficult to train. Jammu and Kashmir, prevailing the internal security situation and across the border terrorism. With legislature, Delhi NCR, Puducherry without legislature under Union Territory. Executive, Delhi NCR. The Lieutenant Governor on the aid and advice of the Council of Ministers. Puducherry. Lieutenant Governor on the aid and advice of the Council of the Ministers. Legislature. The Legislative Assembly on the state list except police, public order and the land and the concurrent list of the 7th schedule. The Parliament on the 3 list and the 7th schedule in the case of conflict by the law made by the Parliament prevails. Puducherry में legislature. The Legislative Assembly on the state list under the concurrent list and the 7th schedule. The Parliament on the 3 list of the 7th schedules in the case of the conflict and the laws made by the Parliament prevails. The without legislature, the other union territory, administered by the president acting as the such external through the administrator. The administrators are the advisory council and the home minister advisory committees are set up to the advise the administrator the matter of the concerning these duties. The parliament on the 3 list of the 7th schedule. The president can make the regulation for the peace and progress and the good governance. In Puducherry, President can make the regulation where when the assembly is suspended. Judiciary, the Delhi High Court, Madras High Court, without legislation, Andaman, Kolkata High Court, Chandigarh, Punjab, Haryana High Court, Dadar Nagar Haveli, Daman and Diu, Mumbai High Court, Lakshadweep, Kerala High Court. The Articles 229 to 241 to Part 8 of the Constitution deals with the Union Territory. Even though all the union territories belong to the category, there is no uniformity in their administrative system. Every union territory is administered by the president acting through the administrator appointed by him. An administrator of the union territory or the agent of the president and not headed of the state like governor. The Delhi it is the only union territory that has a high court of its own. The provision for the administration of duties applicable on acquired territories. Jammu and Kashmir High Court, Common High Court, and the UTs Jammu and Kashmir and the Ladakh. The Ministers of the Home Affairs and the nodal agency for all UTs, the Union Territory of the Jammu and Kashmir, the Union Territory structure, the Union Territory UTs and UT of Ladakh without legislature, and the UTs of the Jammu and Kashmir with the legislature. The Assembly can legislate and no matter in the state list except the public order and the policy which the means under the lieutenant governor's control. Article 229 states that it is administered by the president through the appointed administrator except the demands necessary. Jammu and Kashmir Reorganization Act 2019 applies that article 229A, which governs the administration of the Puducherry and Union Territory of Jammu and Kashmir. Legislative power. Jammu and Kashmir Reorganization Act 2019 allows that Legislative Assembly to make law on the matter in the state list except for the public order and police and the concurrent list as the applicable to the Union Territory. Jammu and Kashmir Reorganization Act 2009 requires that the bill is amended related to the financial obligation can only be introduced in the Legislative Assembly with the recommendation of the Lieutenant Governor, limiting the Assembly and the fiscal matter and the Assembly's the power and subject to the discretion Lieutenant Governor LG matters outside it. The preview of when the required the law, the comparison with the Delhi and Puducherry, like Puducherry Jammu Kashmir Assembly governed by the Article 229A, while Delhi operates under the Districts Article 229AA with the more complex power sharing the framework between the LG and the government. In Delhi case, they are subject to land public order and police are reserved for the LGs. The LG's authority, addition to the public order and police, LG as authorities over bureaucracy and the anti-corruption bureau with the discretionary power over all the matter outside the assembly's jurisdiction. A special provision for the Delhi. The 69th constitutional amendment of the 1919, the special status union territory Delhi resignated to the National Capital Territory of Delhi and designed the administration of Delhi as the Lieutenant Governor. The created the Legislative Assembly as the judicial administration of Delhi. The strength of the assembly is a fixed seventh member, directly elected by the people. The election are conducted by the Election Commission of India. The strength of the Council of the Ministers is fixed 10% of the total strength of the Assembly, that is 7-1. The Chief the Minister 6 ministers. The Chief Minister appointed by the President, not by the if governor. The other ministers are appointed by the President and the advice of the Chief Minister. The minister hold the office during the pleasure of the President. If the case of the differences appointment between the governor and his minister, the governor is to refers to the matter of the President or the decision and the act of the accordingly. If the governor is promulgate ordinance, no such ordinance can be promulgated. Withdraw the without the prior permission of the President. The government of the NCT of Delhi Amendment Act 2021. The key point: the state that the government in the National Capital Territorial Delhi meant that the Lieutenant Governor of Delhi, if gives the discretionary power to the LG, even the matters whether the Legislative Assembly of Delhi is the empowered to the make law. It seeks to be ensured that the LG is the necessarily granted an opportunity to give her or his the opinion before any decision take the council ministers and the Delhi cabinet is the implemented the bar of the assembly of the committee from the making rules and take up the matter concerning the day-to-day administration or the conduct that require the relationship administration decision. Schedule and the tribal area. Scheduled tribal ST 8.6% of population. The Article 244 Administration Schedule and Tribal Area. Article 244A applies that the fifth schedule provision and schedule area in the state order Assam, Meghalaya, Tripura and Mizoram. The Article 244P the provision of the sixth schedule shall be applied in administration of the tribal area in the state Assam, Meghalaya, Tripura, and Mizoram. Scheduled area and presented region of uh, covering the 11.3% of the Indian's land area inhabited various ST communities. The scheduled area and the treated differently from the other area and the country because that they are inhabited by the original and who are the socially and the economically rather than the backward and the special affordable need to made by the improve their condition. Fifth schedule feature the declaration of the scheduled area. The president is empowered to declare an area to be scheduled area consultation with the governor of state concerned. The governor should be submit report to president regarding the administration of the such area. The executive power of the center extend giving the direction to the state regarding the administration of such area. Each state have scheduled area and they establish the tribal advisory council consisting of the 20 members, three-fourths of the whom are to be representatives of the ST and the state legislative assembly. A similar council can be the established in the state having the scheduled tribes but the not scheduled area there in the it represented so direct. The governor can make the regulation within the consultation from the tribal advisory council that may be prohibit the restricted transfer to the land by the among the member of the scheduled tribes and the regulate the businesses of the money lending in relation to the scheduled tribes. The largest administrative unit the forming the scheduled area and has been the district and the lowest the cluster of the village and the block. Also, regulation may be repealed and they be parliament or the state legislature, which is the applicable to the scheduled area. But all such regulation required to the asset of the president. The constitution requires the president the appointment by the commission to the report of the administration of the scheduled area. So the 1960 Union Labour Commission of the 2002 the Dilip Singh the Bhuria Commission was the appointment. Sixth schedule and the tribes in Assam, Meghalaya, Tripura and Mizoram. Uh, no, Monolith ATM without money. Monolith ATM without money have not the assimilated much the required the differential treatment so the protect the interest of the scheduled tribes. The tribal area, these the four states have the constituted and the autonomous district, but they do not the fall outside the executive authority of a state concerned. So governor is the empowered to organize the reorganizing autonomous district. If there are the different tribes and the autonomous district, and the governor can be divided district into the several autonomous region. The autonomous district has a district council consisting of the 30 members, four nominated by the governor, tenure the pleasure of the government, plus the 26 elected tenure 5 year. Each autonomous region also has been the separated regional council. Both these council make the but the required asset of the governor. The district and the regional council within their the territorial jurisdiction can be constituted village council. Or the court trials suit and the cases between the tribes. They hear the appeals from them the jurisdiction of the High Court, and over these suits are cases in the exercise the governor. 7. The district council can be make the regulation of the control of the money lending and the trading of the non-tribal, but the such regulation required the asset of the governor. The 8. The district and the regional councils are empowered the assets of the collect the revenue and the impose the certain specific tax. The act of the Parliament of a state legislature do not apply the autonomous district and the autonomous region of the applicable within the specific modification of and the exception. The governor can appoint the commission to examine the report and may matter relating to the administration of the autonomous district and the resignation which may be dissolved at the district and the regional council on the recommendation of the commission. If the governor has the power to the annulment and the suspend the act of the regulation of the autonomous district and the regional council. The CAG shall be cause the amounts that the autonomous district and the regional council funds to be audited. Note: the Constitution does not define the criteria for the reorganization of the scheduled tribes. Meghalaya Khasi Hill Autonomous District Council, Jaintia Hills the Autonomous District Council, Garo Hills Autonomous District Council, Mizoram. The Chakmang Autonomous District Council, Lai Autonomous District Council, Mara Autonomous District Council, Tripura. The Tripura Tribal Area Autonomous District Council, Assam. The Daima Hearts Autonomous Council, Khabri Alangos Autonomous Council, Bodoland Territorial Council. Thank you for watching.